Good morning. All right, I'll try that again. Good morning. Can everyone hear me?
Good morning.
Good morning. All right, one more time because your mic wasn't on. I want to hear everybody in the jail so I can make sure that you guys are awake with me. Good morning.
Good morning.
All right. My name is Judge Stacy Shulman. I will be the judge who's going to be presiding over first appearances this morning. Before we go any further, and I just want to wait till everybody comes into this courtroom, I'm going to swear everybody in. So in a second, I'm going to ask you all to please raise your right hands. Can you all please raise your right hands as best you can? All right, do each of you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? No, they can raise their right hands.
I do.
Yes?
Swear.
I heard like one person say it. Okay, I got some more yeses. All right, thank you. You can put your hands down now. All right, as I said, my name is Judge Shulman, and I will be presiding over first appearances today. Just a few reminders. This is only a first appearance or bond hearing. This is not your trial. My job is only to determine whether or not there's probable cause that you should be held or what your bond should be. This is not your time to tell me all the reasons why it didn't happen the way the police are saying it happened. So it's just important to keep that in mind, especially because you have an absolute right to remain silent, because if you're coming before me, you've been accused of a criminal charge. There are public defenders both in the main jail as well as here with me, and I would say that they would probably encourage you not to talk about the facts of your case. Nothing that I am deciding today requires you to talk about the facts of the case. So please, I would encourage you to exercise your right. You can waive that right if you so choose, but please know that no question I'm asking is intended for you to tell me why it did or did not happen that way. Okay? Does everybody understand that?
Yes.
Okay, and the only thing I'm determining today is probable cause, which is one of the lower standards here in the court system, okay? So we're going to go in order, but for the first case that I'm going to call, which is Jonathan Samudio Fascione. I apologize, I think I'm mispronouncing that. He's on page 22 of the docket, is that correct? We're just skipping it because we have a detective who's here in court with me.
Your Honor, can we recall him? He's not here right now.
Okay, so we'll put him, we'll hold off. If you could just let me know once he comes down so that I can get this detective out, okay?
Thank you, Your Honor.
Okay, thank you. So then we'll go in order the docket. First up is Shaniqua Rory. Are you here on Miss Rory's case? You can come
Yes,
down,
Your
sir.
Honor.
Okay, and I'm gonna apologize in advance for mispronouncing names. It's probably gonna happen. Please correct me, okay? All right, so Miss Rory is before the court for the charge of battery, touch or strike, domestic. Sir, could you state your name for the record?
Yes, my name is Alvin Posey, P-O-S-C-Y.
Okay, and you are the listed victim in the case, correct, sir?
Yes.
Okay. The court has reviewed the probable cause affidavit and does find probable cause. What is it, if anything, you want to tell me, Mr. Posey?
Good morning, Judge. I'm sorry to waste the court time, but I'm really not the victim of this case.
Okay. All right. Well, the court has found probable cause based on the allegations in the probable cause affidavit. Does Ms. Rory have any priors?
Yes, Your Honor. She has a 2013 arson in the first degree and resisting.
Okay. Is Ms. Rory able to post bond?
Yes, ma'am.
Your Honor, if there is a low bond, she can post it. She's lived in Florida 7 years. She has an 11-month-old baby right now, and it's with the godmother. She does have a job. She's set to work tomorrow, I believe, and she does have somewhere else to stay if the court does not want Miss Rory to stay with the alleged victim.
Okay. Bond will be set in the amount of $1,000. She will be ordered to have no contact with Mr. Posey at this time. Okay, so Ms. Rory and Mr. Posey, you guys aren't to have any contact. Now, that's something that can be reviewed by the assigned judge as the case develops, but based on the facts and circumstances here, the court is making a finding of probable cause and you should not have contact.
The people that came up to the house, Your Honor, Saturday, we already had made arrangement that her and the baby do have somewhere to stay.
Sure.
And I would be the one that would step out until this case is resolved.
Okay. That's fine. I'm glad you're able to work it out, but I want to keep the two of you separate, particularly because I'm a dependency judge and you don't want to end up in front of me because of ongoing domestic violence between the two of you. Be prepared that the Broward Sheriff's Office is probably going to come out and investigate as a result of these allegations, but let's keep you two separate so you guys can figure out what's going on and then we can get everybody back home together, okay?
Yes, ma'am.
All right, so Ms. Rory, you understand no contact, direct or indirect with Mr. Posey at this time?
Yes, ma'am.
All right, so we'll stand in recess this to Ms. Rory.
Okay.
Okay?
Yes.
Thank you. So it's a $1,000 bond, no contact with the victim.
Thank you, Your Honor.
Okay. Next up is Virginia Castillo. Okay, sir, you can come up to the podium.
Your Honor, do we have a Spanish interpreter?
We do. Un momento. All right. And our interpreter, we do have the interpreter. Miss Castillo, can you hear the interpreter? Hold on. Uno. Okay.
Señora Castillo, tenemos la intérprete, ¿puede usted escucharla?
Sí.
Yes.
Okay. All right. So, Miss Castillo, you're before the court on the charge of domestic violence, battery. And sir, if you would state your name for the record.
Señora Castillo, usted está en el tribunal bajo el cargo de agresión por violencia doméstica. Señor, por favor, diga su nombre.
Virginia Castillo.
Okay. No,
Salvador
sir.
Sanchez.
Sir.
Señor.
Can you state your name?
Puede dar su nombre. Salvador
Okay.
Sánchez.
All right. And Mr. Sanchez is the listed victim in the case. What is it that you want to tell me, if anything, Mr. Sanchez?
Señor Sánchez, usted es la víctima en el caso. ¿Qué es lo que me quiere decir?
Just for the record, the court does find probable cause based on the allegations in the
Para el
affidavit.
acta, el tribunal encuentra causa probable.
All right.
Tengo más de 30 años de casado con Virginia Castillo.
I want to tell you that I have more than 30 years of marriage with Virginia Castillo.
Estamos pasando por una travesía muy fuerte.
We're going through very difficult times.
Okay.
Yo de 27 años murió en un accidente hace 5 meses, 6 meses.
Our son, that is 27 years old, died in an accident 5 months ago.
Okay.
Entonces eso le ha hecho mucho daño a ella.
So that has caused a lot of harm to her.
Está muy estresada y está bebiendo medicamentos.
She's very stressed and taking medication.
Está sufriendo de la presión alta, el azúcar,
She's suffering from high blood pressure, diabetes,
el hígado y el páncreas.
the liver, and pancreas.
Ella está bebiendo como 6 medicamentos y eso como que no la tiene bien.
She's taking like 6 medications, and that's not doing good to her.
Okay.
Es una persona muy buena, amable.
But she's a very nice and kind person.
Okay. First of all, sir, ma'am, let me say how sorry I am for your loss. I can imagine that this is a very stressful time for you and your family. Unfortunately, though, the court has found probable cause, and it sounds like, as you've indicated, you're going through some difficult times. Is Ms. Castillo able to post a monetary bond?
Disculpen ambos por este momento tan difícil que están pasando, pero el tribunal ha encontrado causa probable. ¿Puede la señora poner una fianza?
Your Honor, she can afford a low bond. As her husband has stated, they've been married for 37 years. She's lived in Florida since 1982. She does have a job at Memorial Regional Hospital. She has family here. I believe this is her first time being arrested, if the state could double check that.
I found no priors.
Yeah, it looked like she scored 0 on the information I had. so.
Ella puede poner una fianza baja, como dijo su esposo, han estado casados por 37 años. Ella tiene un trabajo en el Hospital Memorial, tiene casos anteriores. El fiscal indica que no.
Okay. So the court's going to set bond in the amount of $1,000.
El tribunal va a asignar una fianza de $1,000.
But I am at this time going to order that Mr. Salvador and, I'm sorry, Mr. Sanchez
En este momento voy a indicar que el señor Sánchez
and Ms. Castillo not have any contact.
y la señora Castillo no tengan ningún contacto.
Okay?
Okay? But why?
Because, sir, there was a violent incident that occurred between the two of you,
Señora, porque hubo un incidente violento entre ustedes dos.
and at this point, the court finds that the two of you should not have any contact.
Y en este momento el tribunal encuentra que eso no debió haber ocurrido. She's not like that
Your Honor, can I request that we do an order for no harmful contact?
Puedo
No.
solicitar
This
una
court does
orden
not
para
do no harmful contact.
contacto no violento. No.
That's the state of the law,
Esa es
that
la
they not
ley.
have no harmful contact.
Eh,
That didn't work.
que no
And so
pueden
at this
tener
point,
contacto
they'll be ordered to have no
violento y no
contact.
ocurrió. Entonces voy a ordenar que no pueden tener ningún tipo de contacto.
Okay?
I cannot have direct contact with her.
You cannot at this time,
No,
sir.
señor, en este momento.
What's gonna need to happen is one of you is gonna have to live, if you live together, one of you will have to stay somewhere else.
Lo que va a ocurrir es que si ustedes viven
And as the
juntos,
case develops, there can
Uno
be a
de ustedes
determination perhaps by another court
va a tener que
depending on how
mudarse
things go,
afuera, quedarse en otra parte, mientras
as to
el
whether or
caso
not you can have contact.
se resuelve o hasta que el tribunal decida que pueden tener contacto.
But based on the facts of the case as presented to the court at this time, even recognizing the difficulties the two of you are going through as a result of the loss of your son, the court finds that a no contact
Basado en
order
los
is
hechos del
warranted.
caso, aún reconociendo que están teniendo un tiempo difícil por la pérdida de su hijo, el tribunal encuentra causa probable.
Okay? Thank you.
Gracias.
All right, next up is Jasula Alexis.
Your Honor, the person you previously called on page 22 is present.
All right, let's do Miss Alexis, and then we'll call Mr. Samudio. Thank you for letting me know.
No problem, Your Honor. And Miss Alexis does speak Creole primarily, but she does understand English and she does want to go forward. So if we could just go a little bit slower for
Sure,
her, Your Honor.
not a problem. So,
Thank you.
Miss Alexis, you can hear me and understand me?
Yes, ma'am.
Okay, and have you been able to understand when I've been talking to the other people so far this morning?
A little bit, but
Oh.
yeah.
Okay, if there's any issue you have understanding me, please stop me and let me know, okay, ma'am?
Yes.
Okay, so Miss Alexis, you're before the court on a domestic violence battery. The court has reviewed the probable cause affidavit and does find probable cause. Is Miss Alexis able to post a monetary bond?
Yes, Your Honor. However, just for the record, the cousin does not live in that residence.
Okay,
And Miss Alexis can afford bond. She does have a job. She works at Burger King. She's lived in Florida for 5 years and does have family. And again, I don't believe the alleged victim suffered any injuries aside from water.
okay, and does Miss Alexis have any priors?
I can find it.
Okay, so bond will be set in the amount of $1,000, but Miss Alexis is gonna be ordered to have no contact with the victim, Miss Valmier. Do you understand, Miss Alexis?
Yes, ma'am.
Okay, so I'm just telling you, Thanksgiving, Christmas are coming up. You guys are gonna have to celebrate separately. If the whole family's getting together, only one or the other of you can be there. You cannot be there together. Do you understand?
Yes, but they never can. We never do anything together.
They don't do anything together. Your
Okay,
Honor, so
okay. All right, I just like to say it because people think there's holiday exceptions in the law, which there are not, okay? So with
Thank you, Honor.
$1,000 bond, no victim contact. Thank you. All right, now we're gonna call Mr. Jonathan Samudio Facion, and I apologize because I'm probably mispronouncing that.
You cool. It's all right, man.
He's on page 22. And Detective, if you would please announce your name for the record?
Detective Paul Bradley.
Okay. So Mr. Samudio Facion is before the court. Count 1 on false ID, count 2 on a drug paraphernalia charge, counts 3 and 4 have to do with an arrest warrant with a threat to kill and false report of an explosive device. As I discussed with both the state and the defense as we were preparing for these hearings, I do show that on the arrest affidavit, there was a no bond placed by Judge Shearer. I don't see any reason to disturb that at this time. Does the Public Defender's Office have anything to say to the contrary?
Your Honor, I believe it's for magistrates. That's why it's set at no bond at this time.
Okay. This is a bondable offense, correct, State?
It is, Your Honor.
Okay. So what bond, if any, would the state be requesting?
Your Honor, even though it's a bondable offense, we are asking, based on the charges and the circumstances surrounding and the safety of the community, to hold a defendant no bond on these charges.
Okay.
And if the court is going to set a bond, I'm going to be asking on the both count 3 and count 4. I'm going to be asking for a $250,000 bond on each count.
Okay. All right, so did the public defender's office wish to be heard? Regarding the state's request, they're requesting a total of a $500,000 bond, 250 on each count.
Your Honor, my client cannot afford that amount, that high amount of a bond at this time. My client is requesting that the court consider a lower bond amount or pretrial. Do you live in Broward?
Yes, I live in Broward, but
How long have you lived in Broward?
all my life.
He's lived in Broward all his life, Your Honor.
Yeah.
He has a job. Where you work?
Security at a club. I just started last night, 2 days ago.
Started security at a club, Your Honor, about 2 nights ago.
Okay. The court is going to set bond in the amount of $250,000 per count, for a total of $500,000 on counts 3 and 4. In conjunction with the bond on count 1, that's $501,000. All right. All right, we'll stand in recesses to Mr. Samudio Facion. All right, next, returning to the regular order of the court's docket, is it Whitney Presendor?
She's at North Broward, Judge?
Thank you. Thank you. Ma'am, how do you say your name?
Whitney Presendor.
Ms. Presendor, you're before the court on count 1 for a domestic violence battery. Counts 2, 3, and 4 are traffic KPSs. The court has reviewed the probable cause affidavit and does find probable cause. Is Ms. Presendor able to post a monetary bond?
She can't afford a low amount.
Hold on, I'm talking to the lawyer here, okay, ma'am? So just,
She has indicated to me that she can't afford a reasonable bond. However, if Your Honor is inclined to go a little bit higher, we would be requesting pretrial release. Based on the probable cause itself, it looks like the alleged victim did not provide a sworn statement, did not wish to be checked out for any alleged injuries, did not seem like he really wants to go forward. And looking at Ms. Presendor on the screen right now, it appears she has an injury, so we would also be requesting a photo order.
okay. So the court will authorize the photo order. Does the state aware of any other priors besides the traffic matters before the court?
No, Your Honor. I'm just seeing just the traffic. That's it.
Okay. So, bond will be set in the amount of $1,000 as to count 1. Count 2, the traffic KPS is already set at $1,000. Count 3 and 4 are ROR. So it'll be a total bond of $2,000. However, Ms. Presendor, you're ordered to have no contact with the victim, Lebanon's Valleys or Vales. Do you understand?
Yes.
And that means no contact, direct or indirect, no calling, no texting, no social media, okay, ma'am?
No problem.
All right, thank you.
Thank
Next
you.
up is Barbara LaRosa.
Yes, Your Honor.
She's at Maine.
Maine, thank you. Good morning, Miss LaRosa.
Good morning.
Sir, are you here on this? Oh, okay. All right. So, I'm sorry, it's Miss LaRosa Suarez, correct?
Correct.
Okay. Ms. LaRosa Suarez, you are before the court on count 1 on an aggravated battery, pregnant female. Count 2, a battery. The court has reviewed the probable cause affidavit and does find probable cause. Does Ms. LaRosa Suarez have any priors?
I just checked the first system. No, Your Honor. I'm checking the second one.
Okay.
Your Honor, Miss La Rosa does not live with the alleged victims. Her mom is currently in the hospital. She does have a job. She works at a bakery, and she also does house cleaning, and she can afford a low bond.
What's a low bond?
$1,000 bond, Your Honor.
Okay. Would she like pretrial instead? Because the bond's not going to be set at $1,000.
I can't find any more.
Okay.
Yes, Your Honor, if the court would allow for standard pretrial.
I'll give her a level 2 pretrial. So she can go to work, she can go visit her mother at the hospital, we'll include that as well. But she's not going anywhere else besides work, church, school, and to see her mom at the hospital.
Your Honor, would the court consider a lower level, just considering she has no priors and she does have children and her mom is in the hospital?
That's why I'm giving her pretrial and not setting just a monetary bond.
How much was the number?
If the court was to set a bond, Your Honor, my client would like to know how much.
It would be $5,000 just to count one.
And count two, Your Honor?
I would set 1,000 for count two. For a total of $6,000.
That's fine.
Your Honor,
Take the bond.
my client would like to take the bond amount.
Oh, okay.
Just go ahead.
Thank you, Your Honor.
All right, so it'll be $5,000 just to count one, $1,000 just to count two, for a total of $6,000. And ma'am, you're ordered to have no contact with either victim, direct or indirect. Do you understand?
Oh, that's fine. I'm done with that. All my family.
Okay, very good. Thank you very much. Good luck to you. Next up is Alyssa Murphy.
Yes, Your Honor, that's in Maine. I believe it's a medical reset.
Okay. All right. Claudia McCrae.
North Broward.
Thank you.
Yes.
Good morning, Ms. McCrae. Can you hear me?
Yes, ma'am.
Okay, Ms. McCrae, you're before the court on a misdemeanor capias. Bond has already been set in the amount of $200, so you need to be able to post a $200 bond.
Judge, Ms. McCrae indicated to me that she was interested in resolving if Your Honor is inclined to, because it is possession of drug paraphernalia.
Yeah, and I went to court on this already.
Okay, I'm not inclined to resolve this. I'm looking at, she is according to the paperwork presented to the court, I'm just reading the way it's captioned, Florida career offender, and it looks like she has multiple cocaine offenses, so, and if she's indicating she already went to court and took care of this, then I'm not gonna have her take a plea on something that could potentially be resolved.
No, I got community service on it.
Okay, well, ma'am, you need to go, you'll have court, when is her next court date gonna be, do we know?
I need to resolve it. I have a lot of appointments coming up. I have an appointment tomorrow. I have so many things I'm dealing with.
Okay.
Court.
Well, unfortunately, ma'am, I'm not in a position to resolve the case today, so, you'll have to go back in front of your assigned judge, and if they'll resolve it at that time, then you can resolve it at that time.
So what's open when?
Can she be put in front of Judge, Powell, I guess? I just wanted her to have a future court date.
I have so much stuff going on.
Hold on one sec, ma'am, I'm trying to hear what the clerk's telling me here, I'm sorry. You'll be back in front of the court in the next 2 to 3 days, ma'am, okay? In the meantime, if you can post a $200 bond, you can get out, okay? All right, thank you. Next up is Mabel Flores. Thank you. Good morning, Ms. Flores.
Good morning, Your Honor.
All right. So, Ms. Flores, you are before the court on a charge of child abuse. And sir, what's your name?
Elric Flores.
Okay. And Mr. Flores, you are the alleged victim in the case, correct?
Yes, ma'am.
Okay. The court has reviewed the probable cause affidavit and does find probable cause. What is it that you want to tell me, Mr. Flores?
She didn't really hit me at all. I don't have any marks. It's just a one-time thing, an accident. I don't really see.
And I appreciate you being here, Elric, and I appreciate you speaking on behalf of your mom. Is Ms. Flores able to post a bond?
Yes, Your Honor. But I was trying to. I am a good mother. I've always been great to my children. I'm a single mother. I'm the only one that provides for them. His father is not in his life, and I would like to start reparations and making sure that we work on our relationship so something like this never happens again. And I request that I be set for ORO.
RORs, that's what you're asking for. Okay, the court is not inclined to ROR.
Judge, would you be willing to do standard pretrial in the light of the fact that her son is here? She is a single mother.
Can we do a standard pretrial with drug testing, alcohol testing? Okay, so what I'll do is I'll put her on standard pretrial release, but you, oh. Hold on, ma'am, when, there's somebody else here, so just stand by for a second, okay, Ms. Flores? And ma'am, you are?
I am her mother.
Okay, you're Ms. Flores' mother and Elric's grandmother?
Yes.
Okay, so what I'm gonna do is I'm gonna place Ms. Flores on standard pretrial release, which means you're gonna have to report by 9 a.m. tomorrow, is that correct?
Yes, within 24 hours.
Within 24 hours, of your release, you need to report to pretrial, and then you're gonna have to call in at least once a week. But I'm also making it as a condition of that pretrial release that you be subject to drug and alcohol testing. Okay? So that means you're not gonna drink at all while you're being monitored on this case. Do you understand?
Yes, ma'am.
Okay, alcohol is a legal substance. For you right now, it's off limits.
Okay, ma'am.
Oh, I'm sorry, twice a week. You're gonna have to call in twice a week. I misspoke. You're calling in twice a week, and then they'll tell you to report for your drug testing as appropriate, okay?
Can I say something?
Yes, ma'am.
Now, let me ask you a question, ma'am. Do you, live with them?
Right now, yes, I'm taking care of the 2 kids.
Okay, because the other thing I'm gonna order is that Ms. Flores have no unsupervised contact with Elric
Okay.
or
I
any
will.
child under the age of 18.
And I want to say something in behalf of my daughter.
Okay,
She's a great mother. She provides for the kids, and she's so amazing. She have a breast cancer, and she fight it. So she doesn't deserve. I swear in front of God, she doesn't deserve this, because he worked from the morning to night.
okay.
So please have mercy.
Okay, well, so I'm gonna let her get out, okay? But I'm gonna make sure that we keep the kids safe, that she gets her, I don't know what's going on that caused this incident to occur, but we need to get things straight so things don't get worse. We want them to get
Yeah,
better.
but in 16 years, he never hit him. He can say that.
Okay.
He can say that.
And I appreciate that, but that's what should happen, okay? So, like I said, I'm gonna let her get out on pretrial release. We're gonna make sure she's not drinking or using drugs, okay? And
She doesn't use drugs.
okay, well, that's good. So we'll just double check that. She's not gonna be drinking, and she's not gonna have any unsupervised contact with the children at this time. I wanna make sure you or somebody else is around so that if there is a problem, you can intervene instead of Elric at 16 years old being the one to intervene. Do you understand?
Yeah, yes, yeah.
Okay.
I have no problem.
Okay, very good. Ms. Flores, do you have any questions?
No, ma'am. Thank
Okay.
you.
At least once a month. I'll put a minimum of once a month.
Judge, you said with any no unsupervised contact with the victim.
With victim or anyone under the age of 18.
or anyone.
Okay? All right, we'll stand in recesses to Ms. Flores. Thank you. Good luck to you. All right. Next up is Yvette Williams.
Oh, it's for our judge?
Thank you. All right, thank you. Good morning, Ms. Williams.
Good morning.
All right. You are before the court on one count of petty theft second degree and one misdemeanor capias.
Yes.
Is Ms. Williams able to post a bond?
No.
She can't judge. She's what we would be asking for her to either be our award or standard pretrial release. She has also requested that I see if Your Honor would be willing to resolve these cases. Miss Williams has told me she suffers from congestive heart failure and is feeling a little shaky today. And is
Okay.
uncomfortable, so she needs to get out and have access to her medication.
Okay. And I see that obviously the capias is for a theft and she's before the court on a new theft. State aware of any other priors?
Yes, and I would request that the court not resolve this.
I'm
Count
not-
one is a felony.
I'm not resolving the cases.
And,
I'm just asking for purposes of release.
She has a 1983 robbery, no weapon, ag assault, ag assault. She also has a grand theft of the second degree possession of cocaine, theft.
What about in the years that start with the 2, like in the 2000s or 2010s?
She has 2010 traffic criminal operating without a valid license, 2006 possession of drug paraphernalia, 2004 grand theft in the third degree, 2003 possession of cocaine and paraphernalia.
Anything since 2010?
Not in this, not that I'm finding in this system, Judge.
Okay. So what I'm going to order is that Miss Williams she's not going to be ROR'd given the fact she's here for a capias. So I will place her on standard pretrial. Okay. So you're going to have to call in. You're going to have to report within 24 hours, ma'am, and then call in twice a week. Okay? And make sure that you make those court dates, okay?
Yes, ma'am.
All right. And the other thing is you're going to be ordered not to return to the Walmart at 2300 West Atlantic Boulevard. Do you understand?
Ma'am.
Okay.
Yes,
Do
ma'am.
you have any questions?
So I get out today and do my pretrial release?
You'll get out, and then you have to report to pretrial release within 24 hours. So you're going to need to go there.
Okay, all right.
Okay, you don't go there today. They're not going to be open today. So if you get out later this afternoon, you'll go tomorrow, okay?
Okay, thank you.
Yes. Yes. For the capias as well, okay?
Thank you.
All right, good luck to you, ma'am. Feel better.
Okay, thank you.
All right, April Pritchett.
She's also at North Broward.
Thank you.
Good morning, Your Honor.
Good morning, Ms. Pritchett. You're before the court on a charge of grand theft. The court has reviewed the probable cause affidavit and does find probable cause. Does Ms. Pritchett have priors?
Not that I can find, Judge.
Okay.
Checking my
Then I'm gonna leave it as a standard bond and the amount of $1,000.
Ms. Pritchett has indicated to me that she can't afford even a $1,000 bond, and we would be requesting for either be ROR since she doesn't have any priors, or for her to be released on some type of pretrial.
Okay, it's not gonna be an ROR, given the fact that this is a felony. State, do you have any other
I
information?
checked both systems. I
Okay,
can't find anything.
so Ms. Pritchett will be placed on standard pretrial release. So Ms. Pritchett, you're gonna get out, you have to report within 24 hours, and you'll have to call in twice a week. You're also gonna be ordered not to return to the Saks at Galleria Mall. Do you understand?
Understood.
Okay, do you have any questions,
Yes.
ma'am?
No, I don't.
Okay, so standard pretrial release, no return to the Saks. Oh, it's not, okay, so it's the Saks, I apologize. Oh, at Sawgrass.
Yeah.
Sorry, the Saks at Sawgrass. Off Saks, I think it is. Okay. Caroline Shawi?
She's at Maine?
Maine, Your Honor.
Thank you.
Good morning.
Good morning. Can you hear me? How do you say your last name, ma'am?
Like you said.
Shawi? Okay, very good. Ms. Shawi, you are before the court on 2 separate violations of community control. Judge Lynch has set no bonds on those, so you will be held no bond. However, you will go in front of Judge Lynch this Tuesday, November 5th at 8:30, okay? All right, thank you. Best of luck to you, ma'am. Next up is Carla Tanzini, North Broward. Good morning, Ms. Tanzini, can you hear me?
Yes, I can.
Okay. Ms. Tanzini, you are before the court on 1 count of possession of cocaine, 1 possession of methamphetamine. The court has reviewed the probable cause affidavit and does find probable cause. Is Ms. Tanzini able to afford a bond?
She is not, Judge, especially with it being 2 counts. We would be requesting for her to either be ROR'd or in the alternative, to be released on standard pretrial. She has lived in Broward County for 3 years. She doesn't have a job right now, but she does have family in the area, and a place that she can stay.
And what's Ms. Tanzini's criminal history, if
Judge,
any?
I apologize. I cannot find this packet at all here.
It was a reset from.
Yeah, from yesterday.
Yeah.
Can I borrow your?
Here, do you want her, how to spell her name?
I would just need her last name and her.
Tonzini,
T-O-N. Z-I-N-I.
and her date of birth is 10/11/80. First name Carla, Carla. Did they show up?
Yes. 2019 offer agree secure loot act adjudicated guilty. 2019 felony committing prostitution adjudicated guilty. 2018 prostitution loot act assignation adjudication withheld. Traffic criminal suspended driving license first offense. Petty theft adjudication withheld. Possession of cocaine and prostitution loot act assignation both adjudicated guilty. Would you like if the court would like more?
Does she have any other drug priors?
Um,
Ms. Tonzini shaking her head no for the record.
She has 2016 possession of drug paraphernalia, 2016 possession of drug paraphernalia. There's more prostitution charges. And for drug, yes, she does. 2014 possession of cocaine. 2014 possession of a Schedule 4 substance. Petty theft.
Okay. I would put Ms. Tonzini on standard pretrial release, but she will be subject to drug testing.
Understood, Judge.
Okay, so she should be randomly drug tested a minimum of once per month. Do you understand, Ms. Tonzini? Okay, so it'll be standard pretrial release on both. They're gonna call you in to test. If you test positive, they're gonna revoke the terms of your pretrial release, okay? So if you need help, go to Banyan or Fifth Street or one of those places so we can get you clean, all right? Okay, very good. Best of luck to you, ma'am. All right, Toledo, I'm sorry, are the Exantis? Okay, so we're gonna take a quick break on my adults. I'm gonna go off, so screen's gonna go black. We haven't left you, and just so I can handle my last juvenile case.
Your Honor, I'm sorry, Maine, the
Yeah.
deputies are asking if we can do the last female.
Oh, sure. Pause, so I can do the last
Thank you,
female,
Anna.
no problem.
It's Toledo
Carter, yes. Miss Carter, you're before the court on an out-of-state felony hold. And that is a no bond hold, so you will be held no bond at this time. Do you understand, ma'am?
Yes, I do, Your Honor.
Okay. All right, so best of luck to you, okay?
Thank you, Your Honor.
Thank you. So now we're gonna go on a brief recess for you all. So stand by. All right, we are back on the court's regular first appearance docket. Turning now to Edwin Francis. Good morning, Mr. Francis. Can you hear me?
Good morning, Your Honor.
Okay, so Mr. Francis is before the court on, I guess it's I was a little confused by it because it looks like it is there's a protection order, it says, but it's charged as a violation of conditional release. Is that just how it's inputted in the bond, in the computer? Anybody able to help me on this one?
I would believe I would believe this would be a misdemeanor. Yes. So let me see.
The way it's listing, it says pretrial release condition violation for domestic violence, but to me it looks like a violation of an injunction. The way it's worded in the probable cause affidavit. It doesn't look like he was on pretrial and violated the pretrial order.
Okay. I believe I believe the way it is, it's based on like a possible order that no contact with the victim. It could be a no contact when he was released. Let me check on the.
No, if you read the PC, it says he had a temporary protection order. It lists a felony case number, but it says that was served and issued with no expiration date.
Yeah, then I see what yes, you're correct, Your Honor.
So it doesn't have a DVCE number, but it looks like it was a violation of a court order for no contact. So, but we all agree this wasn't that he was on pretrial, correct? And that he violated pretrial, correct? Okay. All right, so is Mr. Francis able to post a bond?
Yes, Your Honor, if it's a low bond.
Okay. Well, what's a low bond?
Your Honor, $1,000 bond he could afford. He does have a job. He works as a barber. He's been in Florida 8 to 9 years. He does have family. And, Your Honor, he just wants the court to know that he went to court on the 31st and wasn't aware of the injunction.
Okay, and there is an underlying felony case, correct?
Your Honor, the underlying felony, it looks like it was down-filed to a misdemeanor under case number 19-10952 MM10A. He is set for an arraignment in front of Judge McHugh on November 21st, 2019. I checked the victim on that case according to our system here, and it is the same victim, Malencia. Your Honor, based on the facts and that he keeps bothering this person, and I'm worried for her safety, I'm asking that you increase the bond to approximately $3,000, but please place him on a pretrial with a GPS monitor, Your Honor.
Okay. I will allow him to post the $1,000 bond he has requested, but it will also include pretrial release with a GPS. It's gonna be both.
No problem.
Okay?
No problem.
So we're doing a monetary and pretrial on this one.
What level, Your Honor?
It'll be open schedule,
Thank you, Your Honor.
but GPS monitor, so we're gonna know where you are. If you go near the listed victim, sir, Melanie Palencia, we're gonna know, and that's gonna be a violation of your pretrial release, and so you'll not only end up in custody, but you'll lose your bond.
All right.
Okay? So,
no victim contact, correct?
no victim contact.
Thank you, Your Honor.
All right, do you have any questions, sir? No contact direct or indirect, you understand?
Yes, ma'am.
He
Okay.
says yes, Your Honor.
All right, very good. With $1,000 bond, it's both. All right, thank you. All right, okay. Next up is Marco Alexander Nichols.
He's approaching, Your Honor.
Okay. Good morning, Mr. Nichols.
Good morning, ma'am.
You're before the court on a domestic violence battery. The court has reviewed the probable cause affidavit and does find probable cause. Is Mr. Nichols able to afford a monetary bond?
Yes, Your Honor.
Yes? And what's Mr. Nichols' history look like?
2013, possession of a firearm by a convicted felon, carrying concealed firearm, both adjudicated guilty. Traffic criminal, unlawful tag sticker, operating without a valid license, failure to register a vehicle, all adjudicated guilty. A couple of more traffic criminals, Your Honor. 2000, and then misdemeanors from 1998, resisting without violence, but he has also 98 solicit cell delivery manufacturer cannabis. He was adjudicated guilty on.
Okay.
And a couple.
That's probably the convicted felon.
Yeah.
All right. So I'll set bond in the amount of $5,000 in order that he have no contact with the victim.
Your Honor, instead of that bond, can we respectfully request a pretrial? He cannot afford that bond amount at this time.
What's the state's position?
If he can't afford the 5,000, I believe that's a fair based on his history, but I would request no lower than 2,500 with pretrial along with it, Judge.
Your Honor, we're just asking for a straight pretrial, and he won't live at that location. He could go live with his mother, so there would be no victim contact.
I would do pretrial with a GPS and, but open schedule.
Thank you, Your Honor.
Okay, so
Thank you, ma'am.
it'll be standard pretrial release with a GPS. Oh, sorry. Yes, pretrial with GPS, open schedule. That's what I was trying to say, sorry. No monetary bond, but he will be ordered to have no contact with the victim. Sir, you're not to go near the victim. And to be clear, the person we're talking about is Almo Robleto. You understand, sir?
Yes, ma'am.
All right. If you go around her, you're going to get your pretrial revoked, and you're going to sit in custody. Okay, sir?
All right, thank you.
All right. Thank you. Best of luck.
All right.
All right. Next up is Antoine Smith.
Name, Your Honor.
Okay.
He's approaching.
Thank you.
Your Honor, in this case, may I request that a photo order be,
Sure.
Thank you, Your Honor.
So, Mr. Smith, you're before the court on a domestic violence battery. Court has reviewed the probable cause affidavit and does find probable cause. What kind of monetary bond is Mr. Smith able to afford?
Your Honor, just for the argument for the PC, aside from the alleged victim, the daughter was a witness stating that she saw both of them fighting. She
Okay.
didn't see one versus the other being the aggressor, and Mr. Smith wasn't the aggressor according to the witness.
That's
Your
not,
Honor.
that's not what the probable cause affidavit says. It says that he saw mom and dad fighting, and then the defendant said that they never had he never hit her.
Correct. So according to the witness, there's no saying as to who the aggressor actually was.
Okay, and then your client made a statement that's contradictory to what the witness said, so the court does find probable cause. As far as bond,
Your Honor, he can afford a low bond. He does have somewhere else to live. He does have a job, and he's lived in Broward County approximately 1 year, but in Florida all his life.
and
So he's asking for $1,000 bond, Your
what's
Honor.
Mr. Smith's priors?
2013 DUI property damage / injury adjudicated guilty. And I see here criminal traffic in Orange County, driving while license suspended, revoked with knowledge, adjudicated guilty, and that's all I can see right now.
Okay. The court will set bond in the amount of $1,000 in order that Mr. Smith have no victim contact. Okay, so you're not to have any contact with Zaquita Smith. Do you understand, sir? All right, thank you.
Thank
Best
you,
of
Your
luck.
Honor.
All right, next up is Mark Bonilla.
He's in Maine, Your Honor.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Bonilla. You're before the court on one charge of battery, just the way it's charged, and causing bodily harm dating. The court has reviewed the affidavit and does find probable cause. Is Mr. Bonilla able to post a monetary bond?
Your Honor, before addressing the bond matter, I also need a photo order on Mr. Bonilla.
Sure. We'll
Thank
get
you,
a
Your
photo
Honor.
bond.
And Mr. Bonilla can afford a low bond of $1,000, Your Honor. He does have a job in construction. He doesn't live with the alleged victim, so he doesn't have reason to contact her. He has lived in Broward for 2 years and in Florida his whole life, and he does have family here as well.
Okay. And does Mr. Bonilla have any priors?
2017 from Miami-Dade County, robbery, strong arm, adjudication withheld.
Adjudication, I'm sorry, what?
Adjudication withheld.
Okay. Bond will be set in the amount of $2,500, and Mr. Bonilla will be ordered to have no contact with the victim, Juliana Pollack.
Thank you, Your Honor.
Thank you.
Have a seat.
All right, next up is Sean Rich.
Your Honor, he's in Maine.
Thank you.
That's a medical reset, I believe, Your Honor.
Okay,
Thank you.
thank you. Okay, next up is Denise Simpson.
Good morning, Your Honor.
Good morning, Mr. Simpson. Mr. Simpson, you are before the court in count 1 on a domestic violence battery, counts 2, 3, and 4 on violations of probation. The court has reviewed the probable cause affidavit as to count 1 and does find probable cause. Bond will be set in the amount of $2,500 as to count 1. Counts 2 and 3 are no bond holds pursuant to the warrants, and it looks like count 4 is an ROR. I guess, I don't know why it's listed twice. It looks like 3 and 4 are duplicative. But you'll be held no bond if the judge changes that in counts 2 and 3, then you still have a $2,500 bond on count 1. You're also ordered to have no contact with the victim, Dulce Ochoa. Do you understand, sir?
Yeah.
Do you have any questions, sir?
No.
Okay.
Thank you, Your Honor.
Thank you. All right, next up is Antoine Evans.
He's in Maine, Your
Thank
Honor.
you. Good morning, Mr. Evans. All right.
Good morning. Good morning, Your Honor.
Good, Mr. Evans, you are before the court in count 1 on a domestic violence battery, count 2 on a possession of cocaine, and count 3 on a violation of probation. The court has reviewed the affidavit and does find probable cause for the for counts 1 and 2. Bond will be set in the amount of $2,500 as to count 1, $1,000 as to count 2. Count 3 will remain a no bond hold. Do you understand, sir?
Yes.
In addition, as to count 1, you are ordered to have no contact with the victim, Christina Evans. That means no contact, direct or indirect. Do you understand, sir?
Yes.
Okay. Good luck to you, sir. Thank you.
Thank you.
All right, next up is Jagidi's Nanda.
I believe it's a medical
Still?
reset.
Okay. Yesterday it was as well. All right, Donovan Scrattish.
I believe that's
It's
also
a medical reset too, Judge.
Okay. I think that was a medical reset yesterday too. All right, Wilson Barrios.
Your Honor, he's in Maine. We need a Spanish interpreter in this case.
Un momento. Good morning, Mr. Wilson. Can you hear the interpreter?
Buenos días, señor Wilson. ¿Puede escuchar al intérprete?
Yes.
Yes.
Okay. Mr. Barrios, you are before the court on an ad charge of false name given to law enforcement.
Señor Barrios, usted está en el tribunal por un cargo adicional por haber dado el nombre falso a un oficial de la policía.
Bond will be set in the amount of $100. The court has found probable cause.
El tribunal encuentra causa probable, se le va a poner una fianza de $100.
Do you understand, sir?
¿Entiende, señor?
Sí.
Yes.
Okay, just to be clear though, that's in addition to any other bond amounts already set on the other counts for which you're being held. You understand, sir?
Para aclarar, eso es una fianza adicional a todos los otros cargos por los cuales usted está en la cárcel. ¿Entiende?
Your Honor, can the state just clarify what the other charges are for my client and the bond amounts? He's unaware.
¿Puede el fiscal aclarar los otros cargos que él tiene y las fianzas?
That's what I've been looking for, Judge. Can I have a moment?
Sure. They're trying to look the CSO now. Hold on. Hold on. It's really loud at the jail, so I can't hear. Yes.
Count 1 was the bond amount of $25, which he was supposed to be going to Palm Beach this morning, but that count was not
Okay, so he only has a $25 bond?
It's already paid.
Okay, so, sir, you have a $25 bond as to count 1, but that's already been posted.
Señor,
Okay.
usted, I'm sorry, Your Honor.
No, it's my bad.
Usted tiene una fianza de $25 por el primer cargo, que eso ya se ha puesto.
Okay, now you have another $100 as to count 4,
Ahora usted tiene otros $100 en cuanto al cargo número 4.
I guess counts 2 and 3 relate to Palm Beach. And,
Eh,
and so you need to go to Palm Beach to address those.
El cargo número 2 y 3 están relacionados con Palm Beach y usted necesita ir allá para resolver esos casos.
Okay, sir?
¿Ok, señor?
Okay.
Yes. All
Thank
right.
you, Your Honor.
Next up is Wesley Brooks. Wesley,
Thank you, Your Honor.
Thank you. Wesley Brooks.
Say it again.
Good morning,
How you
Mr.
doing,
Brooks.
Judge?
Good. Thank you for asking, sir. All right, Mr. Brooks, you're before the court on a misdemeanor capias. The bond has already been set in that amount, in the amount of $500. Do you understand, sir?
Yeah.
Okay, so you just need to post that bond to get out. But you will have a court date on November 5th at 9 a.m. with your assigned judge. That's this Tuesday, okay, sir?
Gotcha.
Okay, thank you. Best of luck.
Your Honor, my client at this time cannot afford a bond. Would the court consider pretrial release?
No, that he can go in front of his assigned judge on Tuesday and address it with his assigned judge.
Thank you, Your Honor.
Thank you. All right, next up is G. Tudoyfort Versan. And
Your Honor, that says a medical loan. And
Okay.
there's a status for November 7th at
Correct.
10:30 a.m.
Correct. All right,
Thank you.
so that matter will be reset. Next up is Russell Jackson. I can pronounce that one.
In Maine, Your Honor.
Sure.
Is that last one reset to tomorrow, or he just?
It's on medical loan, so they'll keep setting it. And then, but he does already have a court date set. Okay, Mr. Jackson, you are before the court in count 1, a driving while license suspended, second offense, count 2 on a misdemeanor capias. The court has reviewed the probable cause affidavit as to count 1 and does find probable cause. What is the misdemeanor capias is for another, is the other driving while license suspended? Is that
Yes, Your
correct?
Honor.
Yes.
Okay, so bond will be set in the amount of $250 is to count 1, and there's already a bond amount set in the amount of $250 for the capias.
Your
So
Honor,
it's a
my
total bond of
client-
$500.
Sorry about that. My client at this time cannot afford any bond, Your Honor. He's requesting that he be placed on pretrial. He lives with his girlfriend. He's currently on disability, takes pain medication, he's diabetic, and he's lived in Florida all his life.
I'm not gonna change the $250 capias bond at this time. He's gonna be in front of his assigned judge on Tuesday. He can ask it then, so it doesn't mean anything if I change it as to count 1.
Thank you, Your Honor.
Okay, thank you.
I stay here.
All right. We're going to do one more, and then we're going to take a quick break, okay? All right, so next up is Justin Swain. Okay. Good morning, Mr. Swain.
Good morning, ma'am.
Okay, Mr. Swain, you are before the court on exposure of sexual organs in public. The court has reviewed the affidavit and does find probable cause for the charge.
Yes, ma'am.
Is Mr. Swain able to afford a monetary bond?
He can't. He also wished for me to reach out to see if Your Honor would be willing to resolve his case.
The court is not going to resolve the case of this nature at this time. I do think it involves victim contact. I will, however, allow him to be on pretrial release with level 2 with a GPS monitor, and he will also be ordered to be subject to drug testing a minimum of once per month. Okay, sir? So again, that's going to be level 2
Does that mean I have to
pretrial.
pay my bond or no?
I'm sorry?
Does that mean I have to pay my bond, ma'am?
No, there's going to be no monetary amount, but you're going to have to go out on GPS monitoring, okay? And
Yes, ma'am.
level 2 means you can go to work, you can go to church, you can go to school if you're in school, but that's it. You don't get to go to a
Understood.
friend's house, you don't get to do anything except necessary things that are approved by tree trial. Do you understand, sir?
Understood.
Okay?
Yes,
In
ma'am.
addition, I'm going to order that you have no contact and that you not return to the home of Philomena Dolce at 5769 Washington Street. Okay?
Yes, ma'am. Thank you.
And the only other thing I'm going to order, sir, is as a condition of your pretrial, you are going to be drug tested a minimum of once per month.
Okay.
All right? So if you violate that, if you test positive, you're gonna go back into custody, sir. You understand?
Understood.
Okay. Yes, yes, thank you. Drug and alcohol testing. Do you have any questions, sir?
No, ma'am.
All right. So we'll stand in recesses to Mr. Swain, and we're gonna take a quick 5-minute break for anyone who needs one, like me, okay?
Thank you, ma'am.
All right, thank you. on. I'm just trying. All right, we're back on the record. Can everybody hear me? I know you all can hear me here. Can you hear me at the main jail? Hello?
Yes, Your Honor.
Okay, thank you. All right, we're actually going to go out of order a little bit because we have a victim here who needs to catch a flight. Ricardo Roll is the inmate's name. He's on page 22, I'm told. Is Mr. Roll down yet? Good morning, Mr. Roll. Can you hear me? If he can hear me, his mic's not on.
Yes, ma'am, I can.
Okay, very good. All right, Mr. Roll, you are before the court on aggravated battery, deadly weapon. And I'm told we have somebody in court on this matter. What's your name, sir?
That's the good book, second.
Okay, and Mr. Colebrook, if you would raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can put your hand down, sir. All right, and, all right, the court has reviewed the probable cause affidavit and does find probable cause. What is it that you want to tell me, if anything, Mr. Colebrook?
Just to start off with, Bishop, we would like to say good morning.
Hold on, I can't hear. It's a little loud in the background. Thank you. Yes, sir.
I would like to say good morning.
Good morning. Thank you, sir.
And I would like to apologize to wasting the court time because Ricardo, I know him for more than 5 years. And at that moment, it was just the energy, you know. It never happened like that before. I don't know him as to be a criminal or have any charges or anything. So on my behalf, I wouldn't like to press any charges.
Okay.
You know, because he got to go back together with me, and we're like family members.
So are you saying that you two, I understood that you have a flight to catch. That's why we're calling the case. Where do you live, sir?
I live in Exuma.
Okay, and where does Mr. Roll live?
He lives down in Exuma as well.
Okay, so he doesn't live here. Okay.
Judge, I believe the witness here, there's also someone here in the red. They're saying that they have some sort of criminal history for him in the Bahamas. I'm not sure. I just want to make the court aware of that. I don't know. I can't find anything here, Judge. I don't believe he is.
Is there somebody else who's here? Yes, ma'am? Okay, and she's holding a piece of paper. I can't see what it is. Miss DiLeonardo, did you want to take a look at that? And have you had an opportunity to look at it, Mr. Theshush?
I have not, Your Honor.
Okay, if you want to go over and look. We're just looking at some paperwork, just so everybody at the jail knows what's going on. Ma'am, what was your name? Ms. Saunders presented a piece of paper where she says is Mr. Roll's criminal history, and so they're just taking a look at it.
And Judge, what I'm reading is, it says, it's like a stamped certificate, just notarized. It says, this is to certify that the above named individual has not been convicted of criminal offenses in the Commonwealth of the Bahamas, and the name is listed as Ricardo Roll, date of birth, January 17th, 1985, which appears to be the same date of birth.
And what is that dated?
September 25th, 2019.
Don't know many people who walk around with a certification of a lack of criminal history.
Yeah.
This is a first for me.
It just says subject with no criminal
Yes,
history.
Ms. Sanders, what did you want to say? Oh, you had. Okay. That makes a lot more sense. Okay, thank you for clearing that up. Okay,
Your Honor, what was said? We couldn't hear.
so
her.
what she said, I said it was perplexing to me why someone was walking around with a certification that they don't have a criminal record. And what Ms. Sanders said is, in order for them to come into Florida from the Bahamas, they have to certify that they don't have a criminal history in order to be let in. And so that's why they have it. Okay. Here's my issue. I'm not in a position, Mr. Colebrook, to just dismiss the charges, and pretrial release is not an option, obviously, for Mr. Roll, given the fact that he's going to be out of the country. So I do have, and I'm not going to ROR him on an aggravated battery, especially for someone who does not live in the country. I will set a monetary bond. I would set it at $1,000 in light of his lack of criminal history and the victim's statements, but it's still going to be a $1,000 bond.
And Your Honor, considering the alleged victim is here and doesn't want to prosecute, I just want to make him aware that he could file a waiver of prosecution with the state attorney to move the process along.
Do you understand that, Mr. Colebrook?
If it's not to,
You wish not to prosecute?
yes, ma'am.
Okay, but there's a form you actually have to sign at the state attorney's office, so if you call, they're not open today, but, if you call tomorrow, they can put you in touch with the victim liaison or the assigned prosecutor, or the case filer, I guess it would be, and they can walk you through the process if that's something you wanna do. Just so you and Mr. Roll know, though, it's really up to the state as to whether or not to prosecute, so we have had cases where a victim doesn't want to prosecute, but the state does opt to, though you as the victim do have a constitutional right to be heard, so they would take your input seriously.
So, Your Worship, in this case of the matter, the victim, in this case of the matter, it'll just be transferred over to the Bahamas?
They can't transfer, because that would be across country lines. So that, I don't believe the case could be transferred, but the case could be monitored, and if Mr. Roll does return, he would have to come back here for his court proceedings here. Okay? All right, so it will be a $1,000 bond. What is the state's position? I don't do no harmful contact, because that's like a misnomer. I mean, that's like saying, don't hurt each other. I mean, he's saying, you don't have a problem? Are you afraid of Mr. Roll?
No, ma'am.
Okay.
Your Worship, like I say,
I'm sorry?
like I said, every morning I see Mr. Roll and every evening I see Mr. Roll. It never came to,
What is their relationship between the two of you?
there isn't no relationship.
You're just friends?
Just a neighbor.
Oh, you're just neighbors? Okay. State, what's your position?
I'm going to defer to you on this one, Your Honor.
Way to punt it.
I just I am in agreement with you about the no ROR. There has to be some way to bring him back. But he doesn't qualify for pretrial, and I feel like the bond based on the circumstances.
Okay. I'm not gonna impose no victim contact, given the victim's waiver. You want to have contact with him, correct?
Yes, ma'am.
Okay, and you're not afraid of him?
No, ma'am.
You wanna, if you guys could get on a plane together, you'd wanna get on a plane together with him today,
I would
correct?
love to see that.
Okay, well, I can't promise you're getting on a plane with him together, because he's still gotta get out of jail, but I'm not gonna put any limitations on the contact. Did you have a question, ma'am? Okay. Right. Well, the unfortunate thing is once law enforcement is involved, it sort of has escalated to a point, and then once law enforcement involved, they sort of take it out of your own hands, so, okay? All right, so $1,000 bond.
Thank
All
you,
right.
Honor. My client just wants to let his girlfriend, Miss Saunders, know that she can go talk to a bondsman and try to get that worked out. Thank you, Honor.
Okay, all right, thank you. All right, next up is Tyler Brzezinski. So we're back in the order of the docket. I don't even know what page we're on. What page? Oh, felt like we were further. All right, good morning, Mr. Brzezinski.
Good morning, Your Honor.
Mr. Brzezinski, you're before the court on a violation of probation and misdemeanor. Judge Diaz has said it is a no bond, so you will be held no bond at this time, okay, sir? However, you do have a court date with Judge Diaz this Tuesday, November 5th at 9 a.m., okay?
Can't bond out at all?
Not at this point, no, sir. You need to go in front of Judge Diaz, and perhaps Judge Diaz will set a bond. Okay, thank you. All right, next up is Raymond Fuertes. Or Ramon, I should say, Fuertes.
Morning.
Good morning, Mr. Fuertes. Did I say that right? Is that how you say your last name? Okay, very good. Mr. Fuertes, you're before the court on 3 misdemeanor capiases. Count 1, there's a $250 bond. Count 2, a $250 bond. And count 3, a $100 bond for a total of $600. Those are as set by Judge... Who? Carpenter Toy. So those will be your bond amounts. That's your bond amount at this time, and you have a court date with Judge Carpenter Toy on November 5th at 9 a.m. Okay, sir?
Your Honor, if I may, Mr. Fuertes was in custody, federal custody, and that's why those capias were issued. I don't believe that was willful and substantial, and I don't know if the court would consider releasing him on a lower bond amount at this time, considering they are misdemeanors.
I'm on federal probation. I talked
And
to
he's
my
on federal probation at the
Now,
moment.
my probation officer, he told me about I told him about the bench warrant because I did the credit check. So he told me to come in, just handle it, and if they needed any information.
And he self-surrendered, Your Honor.
Okay, and I think all of that will benefit him with Judge Carpenter Toy, but I don't know what he's on federal probation for. I'm not inclined at this time to change Judge Carpenter Toy's bonds. Okay?
Your Honor.
Thank you. All right, next up is Cyril Swartz.
He's walking up, Your Honor.
Okay. Good morning, Mr. Swartz.
Good morning, ma'am.
All right, Mr. Swartz, you were before the court. Count 1 on possession of drug paraphernalia, count 2 operating without a valid driver's license, and count 3 attaching a driver's license plate not assigned. The court has reviewed the probable cause affidavit and does find probable cause. Is Mr. Swartz able to afford a bond?
No, Your Honor. Does the court have an offer at this time?
The operating without a driver's license, I'm not comfortable resolving driving offenses without a full driving record. Furthermore, I don't know, does Mr. Swartz have prior drug charges?
There's just a lot.
He has a number of prior drug charges, so I don't think,
I'm sorry, not, some of them are, just for the record's clear, 2016, possession of cocaine, possession of drug paraphernalia.
hey, he's not gonna wanna take a plea from the court today.
But
And I'm not comfortable resolving the driving offense, so.
Your Honor, at this time, he cannot afford the amount set. Would the court consider RORing him? He's lived in Florida since 1985. He doesn't have a job right now, Your Honor.
Does he have a place to live? And access to
yeah.
a phone?
Yes.
Okay, so I'll place him on, standard pretrial.
What's that?
So no monetary bond, he'll be placed on standard pretrial release. So Mr. Swartz, you're gonna have to report within 24 hours of your release and then call in twice a week, okay?
And just so the record's clear, Your Honor,
Yeah.
I just didn't want to mislead the court. It's just different crimes that he has. One of them is possession, but one of dealing. I mean, there was I think a burglary of a structure. Or something.
Okay, no, thank you very much. All right. Next up is Roger Lininger.
Is that Maine, Your Honor?
Thank you.
Good morning, Judge.
Good morning.
Roger, come on.
Your Honor, he has trouble hearing, so if we could all just be a little bit
Sure.
louder for him. Thank you.
And counsel, did you want to announce your appearance?
Yes, Your Honor. Davika Carr on behalf of Mr. Lininger asking to be appointed as to counts 3 and 4, which are municipal city ordinances for the city of Fort Lauderdale.
Mr. Lininger, can you hear me? Mr. Lininger,
Yes.
can you hear me? I'm getting as close to the microphone as I can. Can you hear me now, sir?
What did he say?
Can you hear her?
Yes, ma'am.
Okay. Mr. Lininger, you are before the court in count 1 on a false identification given to law enforcement. Count 2 on a resisting without violence. Count 3 on a municipal ordinance violation. And count 4 on a misdemeanor capias. And Ms. Carr, you're seeking only appointment as to count 3?
3 and 4.
Oh, I
Count 4
apologize.
is also municipal ordinance.
Okay. So, Mr. Lininger, are you okay if I appoint an attorney to represent you on counts 3 and 4?
Yeah.
Okay. So, Mr. Shate's office will be appointed.
Thank you.
Is Mr. Lininger able to afford any bond?
No, Your Honor, he is not able to afford any monetary bond at this time.
Mr. Lininger, do you have a place to live and access to a phone?
To a phone?
Right, so that,
Not right now, no, ma'am.
do you have some place to live, sir?
Excuse me?
Do you have some place to live?
Yes, my mother's probably. Yeah.
Okay. So I will place Mr. Lininger on pretrial release. So, sir, you'll have to report within 24 hours of your release from custody. And then you'll have to call in at least twice a week, okay, sir?
Yes, ma'am.
But I am also going to order that they're going to call you in for random drug and alcohol testing. Do you understand, sir?
I guess so. What makes you think I'm alcohol problem?
Well, the fact that you were stopped drinking beer in public, sir. So that's the conditions of release if that's what you want, sir. Do you understand?
Yes.
Okay.
Your Honor, would you be able to waive the cost of those testings?
Is that an issue, waiving the cost of the drug test? Hold on.
Hold on, Mr. Lininger.
Hold on a second.
I will waive to the extent I'm allowed to under the law, otherwise it can be accrued as a judgment.
Okay.
I'm not gonna say he can't have it or not get out, because he can't afford a drug test,
Right. That's just what I wanted to prevent.
okay? All right. Do you have any questions, Mr. Lininger?
No, ma'am.
Okay, best of luck to you, sir.
Thank you, Your Honor.
Thank you.
Thank you. Thank you.
No problem, thank you.
All right, Gabriel Tovar, or
Yeah, that's a medical reset, Your Honor.
sure. Okay. Clifford Ebersol.
He's present, Your Honor, he's approaching.
Okay.
Davika Carr on his behalf asking to be appointed. These are City of Hollywood cases.
Okay. And Mr. Ebersol, do you want me to appoint an attorney to represent you on these cases?
Yes, ma'am.
Okay, so Mr. Shate's office will be appointed. At this time, Mr. Ebersol, pursuant to the capias is issued, you have a bond in the amount of $50 as to count one and $50 as to count two. Okay, sir?
Now, Your Honor, if I may, Mr. Ebersol would like to resolve these. They're both soliciting charges. He was given a notice to appear, but because he's homeless, did not receive notice of his actual court date. So he failed to appear for his arraignments, one on August 22nd and one on October 24th. So he would like to resolve today. He cannot afford his $100 bond.
Okay, well, these are trespasses and without input from the
Your Honor,
victim.
they're just soliciting panhandling charges.
Oh, I'm sorry. I'm looking at the case that brought it in. I actually don't have the probable, let me see, do I have it? I don't have the probable cause affidavits.
Yeah, they're just NTAs for panhandling. I can pull them up if you'd like.
What's the state's position? I mean, I know there are ordinances. Do you have any criminal history?
Oh, history? I can't, I don't have jurisdiction to give an offer on this, Judge. But,
I understand, but what's his criminal history?
let me look it up one moment.
Are you able to say anything?
I'm seeing a 2007 possession of cocaine and possession of drug paraphernalia adjudicated guilty. DUI refusal to submit the blood breath test adjudicated guilty on both. Let me just check the other. I do see something about in the pamphlet here, Judge. It says here adjudication date of 1988, lewd lascivious child under 16 in Volusia County.
He is a sexual offender.
Yeah.
He's a registered sex offender.
From 1988?
That's what it says.
Yeah, it's the flyer is part of the packet.
Okay.
He's shaking his head yes, for the record.
So
Um,
leave the bonds as they are then.
I'm gonna leave the bonds as they are at this point.
Mr.
Okay?
Ebersol, so your bond remains $100, okay?
But, does he have a future court date or it'll be set?
He does not.
Okay. All right, so perhaps you all can get him on the docket.
Thank
Okay,
you.
thank
Have
you.
a nice day, Mr. Ebersol.
All right, next up is
We weren't able to resolve your case, Mr. Ebersol.
Julio Castaneda Morales, and
Your Honor, we need a Spanish interpreter on this case.
okay, thank you. Good morning, sir.
Buenos días, señor. Good morning.
Can you hear the interpreter?
¿Puede escuchar al intérprete? Yes.
Okay. All right, Mr. Castaneda, how do you say your last name?
Señor, ¿cómo pronuncia usted su apellido?
Castiñeira.
Castiñeira.
Mr. Castaneda, you're before the court in count 1 on a charge of DUI. Counts 2, 3, and 4, are DUI with property damage or to a property or person, and count 5, a careless driving. The court has reviewed the probable cause affidavit and does find probable cause. What history, if any, does Mr. Castaneda have?
Señor Castiñeira, usted está acusado de conducir bajo la influencia del alcohol en el cargo número 1, 2, 3 y 4. Conducir bajo la influencia del alcohol con daño a la propiedad o una persona. Y el número 5, conducción temeraria. El tribunal encuentra causa probable. ¿Qué dice el fiscal?
I can't find any, Judge.
Okay.
No puede encontrar nada, su señoría.
Is Mr. Castaneda able to afford a monetary bond?
¿Puede el señor Castiñeira pagar una fianza?
Your Honor, yes, he can. We just need a phone order so he can get some contacts from his cell phone.
Okay.
Sí, su señoría, solamente necesitamos una orden para que él use su teléfono.
All right, Mr. Castaneda will be provided access to his phone. The bond will be set in count 1 in the amount of $1,000. Same with counts 2, 3, and 4. It'll be ROR in count 5. So a total of $4,000.
Señor Castiñeira, se le permitirá utilizar su teléfono en el cargo número 1, $1,000, 2, 3 y 4, $1,000. Y en el 5 se dejará en libertad bajo su responsabilidad fianza total de $4,000.
You understand, sir?
¿Entiende, señor?
Yes, Your Honor, he understands. He just needs to call
Okay,
his family.
no problem.
Thank you, Your Honor.
Thank you. All right, next up is Andrew McCalely. I'm sorry. I
That's
missed-
a municipal ordinance, Your Honor.
Right. How do you say your name, sir? McAlilly. I apologize, Mr. McAlilly. You're before the court on a municipal ordinance for public consumption of an alcoholic beverage. Bond is, I have reviewed the affidavit and do find probable cause. Bond is set in the amount of $25. Do you understand, sir?
Yes.
Okay, thank you. All right, next up is Luis Perez Elias. Luis Perez Elias.
Your Honor, if we may request a Spanish interpreter.
Sure. All right, Mr. Perez Elias, can you hear the interpreter?
Señor Pérez Elías, ¿escucha al intérprete?
Sí.
Yes.
Okay. Mr. Perez Elias, you have been charged in count 1 with operating without a valid driver's license, and then cited in count 2 for driving on the wrong side of a divided highway.
Señor Pérez Elías, usted ha sido acusado en el cargo número 1 por conducir sin licencia válida y en el cargo número 2 por conducir en el lado equivocado de la carretera.
The court has reviewed the affidavit and does find probable cause.
El tribunal ha revisado la declaración policial y encuentra causa probable.
At this time, bond will be set. Does he have any kind of history?
¿Él tiene
No?
algún historial?
All right.
No.
So bond will be set in the amount of $25 as to count 1, and there's no charge on count 2.
La fianza se asignará $25 en el cargo número 1 y nada en el número 2.
Thank you, Your Honor.
Thank you.
Thank you.
All right, next up is Alan Hubbard.
Your Honor, he bonded out.
Okay. All right, next up, Shania Parchment.
Present, Your Honor. And Your Honor, before we begin, he needs a phone order in his case.
Okay.
Thank you.
Okay. All right. All right. Mr. Parchment, you are before the court. Good morning. You are before the court in count 1 on possession of an altered firearm and in count 2 for speeding. The court has reviewed the probable cause affidavit and does find probable cause. Is Mr. Parchment able to afford the monetary bond?
Your Honor, he can afford the bond as is.
Okay, so he's not a convicted felon or anything, correct, Mr.?
I just checked my
The
first
shoes?
system. I couldn't find anything. I'm checking the second one, Your Honor.
Okay.
Does pretrial have anything on him statewide or
Parchment?
Shania?
I didn't have a sheet for him, so. Okay.
I found none in my system.
Okay, so we'll leave the bond as is, $100, okay, sir? The standard bond. And there's no applicable bond on count 2. Okay?
Thank you, Your Honor.
Thank you. Good luck to you, sir. All right, next up is Patrick Drummett.
North Braddock.
Thank you. Good morning, Mr. Drummett.
Good morning, ma'am.
All right, Mr. Drummett, you are before the court on 1 count of trespass. The court has reviewed the probable cause affidavit and does find probable cause.
Ma'am, all I did was stop.
Sir, I don't want you to talk about the facts of the case because everything we're saying is being recorded, and I don't want you to say something that's potentially going to get you in trouble, okay, sir?
Stop for a pack of cigarettes.
Okay, sir. Again, I'm not asking you to explain anything to me. I'm just letting you know that there's no need for you to talk about the case, and in fact, you may do more harm in talking about the case at this point.
Yes, ma'am.
Okay. I have found probable cause. I was going to leave the bond amount in the amount of $25. Can you not?
Yes, ma'am.
Can you afford that bond, sir?
Yes, ma'am.
Okay, but sir.
I got it in my property right now.
Okay, the only condition, sir, though, is that you are not to return to the mobile gas station located at 3151 West Hallandale Beach Boulevard, okay?
No problem.
All right, they don't want you to come there. Don't go back there.
No problem, ma'am.
Okay, so.
I won't spend a dime in that store ever again.
Okay, good idea, sir. Best of luck to you, all right, sir?
All right.
Thank you.
$25 to $25.
$25 to bond out, and then you'll have a future court date.
And I'm free to go now.
Well, once you post the $25, you'll be free to go.
How long was that going to take, would you say?
That is a better question asked at the jail. I don't have any control over how fast they process things. Okay,
Thank
sir?
you.
All right, take care, sir. All right. Next up is Ajani Dundas. Main jail? Do we know where? Are you Mr. Dundas? And how do you say your last name, sir?
Dundas.
Dundas.
UN. Yeah.
Okay, thank you. I apologize, Mr. Dundas. All right, Mr. Dundas, you're before the court for 1 count of trespass after warning. Court has reviewed the probable cause affidavit, does find probable cause. Can Mr. Dundas afford the $25 bond?
Not at this time.
No, Your Honor.
Okay. Any prior state?
He has an open case. Let me just confirm, Judge.
Your Honor, he cannot afford a bond at this time. He has family here. He's lived in Florida 20 years.
Okay.
I'm asking if you can ROR him on this case.
All right, I'm just looking to see Mr. the Shoosh thinks that he may have an open case, so we're just
He
looking.
does, Judge. He has an open case in front of Judge Merrigan. The case number on that one is 19-01-0011 CF10A. He has a future calendar call date of November 18 in front of Judge Merrigan. I don't know if the court would entertain revoking his bond on the 19-10011 CF10A.
Does he have a bond on that case? What
He is on.
does the BSO show that case?
It says that he posted bond on 10/21/2019, according to Odyssey. Let me confirm what it was.
Need the case number? 19-10011.
I believe his bond amount was $1,000 on that. Battery on a public transit employee.
See that charge? I understand, but he does have a posted bond on that case. And I imagine a condition of any bond is that he not pick up any new offenses.
Your Honor, we don't know who represents him on that case in front of Judge Merrigan at this time. Is it possible to set a date in front of that judge to figure that situation out in regards to revoking a bond?
According to Odyssey's, the public defender's
It
office.
is, yeah, it says.
The public defender's office represents him on that charge.
So that's
And
different.
would the court allow for that public defender to deal with this case?
I mean, I'm not gonna just leave it out there. I'm not gonna leave him with a $25 bond and then he can bond out and then never address the fact that he violated his other bond.
Has he missed court on the 2018 case in front of Judge Merrigan?
It's a brand new case, it sounds like, because he just posted the bond.
That's what I'm saying. Post it.
Yeah, I would encourage you not to say anything, sir.
Except for calendar call on 11/18, I haven't seen any like missed court dates.
So it would be this, and he has a lot of priors, Judge, mostly
I won't say misdemeanors. from
mostly
what I'm seeing.
misdemeanors. I see.
What's the, it's a battery on a public worker?
Battery / public transit employee. So it would be the state's request to on this case that he's on the trespass, I'm fine with the $25 bond, but on the 19-1001 CF10A, I'm asking the court to enter the order revoking his bond at this time.
Your Honor, just for the record, I'm objecting considering the defense didn't have notice of the revocation of the bond.
But so I don't want. I have
Okay, but to be clear, that could have been done in theory by law enforcement or Broward Sheriff's Office upon his arrest. So the court is going to revoke his bond at this time in case number 2019-10011 CF10A. I'll leave it as a $25 bond on the other case. And he has a November 18th date, you said, Ms. DiLeonardo?
Correct, in front of Judge Merrigan.
He's going in front of Judge Merrigan on November 18th, so we can take that issue up with Judge Merrigan as far as reinstating his bond when he goes in front of Judge Merrigan.
I understand that the court has revoked his bond, however, my client's stating that he has a flight on the 6th, so he's asking if the court would reconsider that.
No, because now you're telling me he wants to leave the jurisdiction, which I don't think he's supposed to do when he's on bond. And he's picked up a new offense while he's on bond, so no.
Understood. Thank you, Your Honor.
Okay.
Sign up, do an order, fill up an order for that?
Yes. In addition, just so I don't forget, Mr. Dundas, you're ordered not to return to the Starbucks at 6202 West Sample Road.
He says, thank you, Your Honor.
Okay, thank you. All right. Next up is Jonathan Salamone. Salamone?
He's at the conference facility.
Thank you. Good morning, sir.
Good morning, ma'am.
How do you say your last name? I apologize.
Salamone?
Salamone. Okay, Mr. Salamone, you are before the court on a violation of probation for a misdemeanor charge. This is pursuant to the warrant signed by Judge Evans. Bond has been set in the amount of $1,000 on that charge. Do you understand, sir?
I understand.
Your next court date with Judge Evans is going to be November 5th, which is this Tuesday at 10 a.m. Okay, sir?
Okay.
All right, thank you. Good luck to you, sir.
All right, thank you.
All right, next up is Rudolph Bonholm. Thank you. Mr. Bonholm?
Good morning.
Good morning, sir. Mr. Bonholm, you are before the court in count 1 on account of criminal mischief. I believe that's the misdemeanor, and count 2 is a violation of community control pursuant to the fact that you picked up this new charge. The probation you're on is it's on a Dade County case, I think. Yeah, on a Dade County case. Dade County cases, I should say. The court does find probable cause as to count 1. Bond in that case will be set in the amount of $1,000. Count 2, there is no bond. And you're also ordered not to have any contact with the victim, Gail Tyler.
You said 1,000, Your Honor?
Yes, I'm increasing the bond to $1,000. He allegedly spray painted his ex-girlfriend's car.
And just, Your Honor, I'm sorry, on the case before that, Jonathan Solomon, you put it as $1,000 bond on that one as well? Or what was the bond on that?
It was a $1,000 bond. That was already set by Judge Evans, right? Am I thinking it right? Yeah. Mr. Bonholm, do you understand the court's decision?
Yeah, you said $1,000 bond.
$1,000 is to count 1, and then it's going to be a no bond is to count 2. And you're also ordered not to have any contact with the victim, Gail Tyler. Okay, sir?
Yes.
And Your Honor,
Okay.
I explained to him that if he does bond down on count 1, he would likely be taken to Dade County and not be outright released.
Correct. Okay, sir? No, because you need to address the violation of probation based on this new charge. So they'll bring you to Dade so you can go see your judge in Dade, and that judge can decide what to do, okay?
Okay.
All right, thank you.
Thank you, Your Honor.
Okay, thanks. Okay. Hold on. Okay. Next up is Dustin Mabe. Is that how you say your last name, sir?
It's May.
Mabe. Thank you, sir.
Yeah.
Mr. Mabe, you are before the court on 1 count of burglary with assault or battery. The court has reviewed the probable cause affidavit and does find proof evident, presumption great. At this point, it will be a no bond hold, and you'll be ordered to have no contact with the victim, sir.
Can I ask what that means? A proof?
Sure, hold on, your lawyer is talking. Yes, ma'am.
And
Okay.
Judge, while the full court of the documents do lay out allegations, we don't have sworn witness statements, we don't have the witnesses here, we don't have any kind of surveillance of any kind, we just have the affidavit of the officer. Proof evidence presumption great is a standard that's even higher than beyond a reasonable doubt. The state does have time to file charges, but at this time, nothing's been filed, and we're essentially holding him no bond. To hold him no bond at this point would be pretty much like finding him guilty, since the standard is so much higher than beyond a reasonable doubt.
Okay, but the law does allow the court to make that finding. This does not in any way preclude the defendant from having an Arthur hearing before his assigned judge, wherein he can challenge the evidence more particularly. But at this time, the defendant will be held no bond.
So, Judge.
Thank you. All right, next up is Renee Aparicio. I'm sorry, I know that I said that wrong. Uh-oh. All right. How do you say your last name, sir?
Aparicio.
Aparicio. Mr. Aparicio, you're before the court in count 1 on a possession of cocaine, count 2 on a driving while license suspended, count 3 operating without a valid driver's license, and count 4 failure to wear a safety belt. Pretrial, what do you want to tell me?
Morning, Your Honor. Nancy Matson, pretrial services. He's currently out on pretrial for case number 1900625 CF-10A for grand theft in the third degree. He was placed on pretrial May 27th of this year. We're requesting that his pretrial is revoked on that case, Your Honor.
Did you hear all that?
No, Your Honor, not at all.
Okay, so in essence, Mr. Aparicio has been on pretrial for, under case number 2019-6285 CF-10A. It's a grand theft in the third degree. Based on the arrest for the current charges, they're seeking for the court to revoke his pretrial status.
Your Honor, could we leave the bond as is for now, if the court is going to revoke his pretrial status?
Sure, are you looking for me to set a bond now on his pretrial case?
Then it's a grand theft, Your Honor?
Correct.
And I do see that he's been on PTI statuses, which indicates a lack of a record.
I understand, but now we have 2 charges within.
He doesn't qualify.
He doesn't qualify?
He has priors.
And he is up on November 13th in front of Judge Calra.
Your Honor, I'm going to ask that you revoke his pretrial.
I'm going to revoke his pretrial.
And not set a bond and sua sponte and keep him hold him no bond on that case and then leave the bonds on this. If the court is inclined to, when revoking the pretrial, if the court is inclined to set a bond, I am requesting that you set a higher amount of bonds on this case and a reasonable bond on the next one.
Sure.
And Your Honor, I'm just asking that a bond be set on the case the 2019 case, and then the bond be left as is on this case.
Okay.
Like to hear the priors, Judge?
Yes, please.
The old one I'm seeing is a DUI property damage injury that's in 2002, but most recently, Your Honor, he has a 2018 grand theft in the third degree in Broward, adjudication withheld. 2018 petty theft, adjudicated guilty in Broward. 2018 trespass property other structure, adjudication withheld. That was in Broward also, and now he's picked up this case and another case.
Okay. So bond will be set in the amount of $5,000 for the grand theft case. As to the possession of cocaine charge, bond will be set in the amount of $2,500. There will be no charge or ROR on counts 2, 3, and 4. So for a total amount of $7,500.
Thank you, Your Honor.
Thank you. All right. Trajarium Darrington.
That's North Broward, Your Honor.
Thank you.
No problem, Your Honor.
Good morning, Mr. Darrington. Can you hear me okay?
Yes, ma'am. Good morning.
Okay, good morning. Mr. Darrington, you are before the court on counts 1 and 2 on battery on a law enforcement officer, counts 3 and 4 criminal mischief, and count 5 resisting with. Oh, I gave her the order, I'm sorry. The court has reviewed the affidavit, and does find probable cause for the charges. Is Mr. Darrington able to afford a monetary bond?
He can afford a monetary bond if it's under $5,000 total. However, if Your Honor is inclined to set a bond at an aggregate of over $5,000, we would be requesting pretrial release. Additionally, we're requesting a phone order.
Okay, does he have any history?
2015 possession of cannabis, adjudication withheld. 2015 in Lee County, possession of, it looks like drug equipment. I believe that would be the paraphernalia statute, adjudication withheld. 2017 misdemeanor open carrying of a weapon, adjudicated guilty. And I do have to see Judge. Oh, no, that's closed. 2018 misdemeanor, but I don't know if that's a municipal ordinance case, but it was a DUI, adjudicated guilty. And then in 2019, trespass, structure, conveyance, adjudicated guilty.
Okay.
Occupied.
So the court will set bond in the amount of $2,000 as to count 1, $2,000 as to count 2, $500 as to count 3, and $500 as to count 4.
What, count 5, Judge?
Count 5, I'll set as 1,000, so for a total of $6,000. Okay? All right?
Oh, I'm not getting any pretrial, nothing like that?
No, no pretrial, sir.
All right, thank you.
Okay, thank you. So $6,000 total. Next up is Robert Kennedy.
North Broward. And we need a Spanish interpreter.
Okay. Good morning, Mr. Kennedy. Can you hear the interpreter?
Buenos días, señor Kennedy. ¿Puede escuchar a la intérprete?
Sí, muy buenos días.
Yes, good morning.
Okay, Mr. Kennedy, you are before the court for 1 count of possession of methamphetamine.
Señor Kennedy, usted está en el tribunal por un cargo de posesión de metanfetamina.
The court has reviewed the probable cause affidavit and does find probable cause.
El tribunal ha revisado el reporte policial y encuentra causa probable.
Does Mr. Kennedy have any priors?
¿El señor Kennedy tiene casos previos?
I'm looking at my first system, Judge. I don't see anything. Let me just check the other one. Can pretrial check also, please?
Yo no veo nada, por favor, que el departamento de pretrial chequee también.
No out-of-state prior.
No? Okay.
No.
Is Mr. Kennedy able to afford a $1,000 bond?
¿El señor Kennedy puede poner una fianza de $1,000?
Con el debido respeto, tengo que decirle que no tengo sino $100 en la cartera.
Un momento. With all due respect, Your Honor, I must tell you that I only have $100 in my wallet.
Okay, well, that means he could afford a $1,000 bond
Bueno, eso significa que entonces usted puede pagar una fianza de $1,000
with a bond agent, so.
con una agencia de
So
fianza.
the court will leave bond set at the amount of $1,000.
El tribunal dejará la fianza por $1,000.
Good luck, sir.
Buena suerte, señor.
Do you need access to your phone?
¿Necesita usted acceso a su teléfono, señor?
Sí, por favor.
Yes, please.
Okay, I'll sign a phone order.
Firmaremos una orden para usted acceder a su teléfono.
All right. Next up is Brian Rios.
Main jail.
Thank you. Good morning, Mr. Rios.
Good morning, Judge.
Okay, Mr. Rios, you're before the court on 1 count of possession of cocaine. The court has reviewed the probable cause affidavit and does find probable cause. Does Mr. Rios have any priors? I show that he scores very low on pretrial's paperwork.
A 2008 DUI adjudicated guilty. 2014 DUI property damage adjudicated guilty. DUI property damage adjudicated guilty. And so that was that, and I don't see anything else, Judge.
Okay. Is Mr. Rios able to afford the $1,000 bond?
Yes, Your Honor.
Okay. So bond will be set in the amount of $1,000.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right. Next up is Carlos Ruiz.
Carlos Ruiz. He's approaching, Your Honor.
Thank you. Good morning, Mr. Ruiz.
Good morning, Your Honor.
You are before the court in count 1 on a writ of arrest. Counts 2 and 3 are for violations of probation, capiases. Count 1, there's already a purge or bond amount set in the amount of $1,050. Count 2, there is a no bond hold pursuant to the warrant signed by Judge Michelle Tobin-Singer. So you will be held on no bond on counts 2 and 3. Do you understand, sir?
Yes, ma'am.
Okay, your next court date with Judge Tobin-Singer will be November 5th. That's this Tuesday at 8:30 in the morning. Okay, sir?
Thank you, Your Honor.
Okay, thank you. All right, next up is Antoine Williams.
He's approaching, Your Honor.
Thank you. All right, good morning, Mr. Williams.
Good morning.
You are before the court on 3 counts of burglary of an unoccupied conveyance, and count 4 is a a trespass on a structure. The court has reviewed the probable cause affidavit and does find probable cause. What is Mr. Williams' prior history?
I'm checking. I believe I think he has an open case right now. Can I have a moment, please?
Sure. Does BSO see an open case? Oh. Oh, okay.
Has two open cases right now, under case number 18-1244-1 CF10A. There's actually a KPS out for him on that case. It is I believe, let me confirm. It's a change of charge KPS, so that would be, not sure why that's not on the docket.
Somehow they didn't pick it up.
Those get served at the arraignment.
And I do also see.
No, but a lot of times, because there's an open KPS, like if law enforcement encounters him in the street,
Oh, okay.
it should show as an open KPS that it can be served upon him.
It does say warrant. Yeah.
And then I also see he has another case, Judge, under 19-011495 CF10A, and that case is also in front of Judge Cora with an arraignment date of November 6, 2019. Based on that, and has the court found probable cause in this case?
The court has found probable cause. My question is he on bond or pretrial on the 19 case?
On the 19-11495 case, I will check that one.
I believe he is, Your Honor.
It's a $750 bond from what I can see.
Okay. Because on the 18 case, it's a change of charge, so there's no violation of bond per se. It's just the warrant needs to be served upon him, and he's going to be entitled to a bond. But on the 19 case, he may have an issue. I'm sorry? Okay. So he's, okay.
And the change of charge KPS is for $1,000.
Okay. So
I'm asking the court to revoke his bond.
On which case?
the 19-11495.
I think you can revoke on both, Judge, even because it's a change of charge. So on KPS on the 18 case,
I'm gonna leave the 18 case as is and let that warrant be served upon him, and then he can be magistrated and have a bond set as appropriate. But on the 19-11495 CF10A case, the court is going to revoke Mr. Williams' bond based on the 4 new charges pending before the court. As far as these cases, these charges, he is still entitled to bond. So, but bond will be set in the amount of $5,000 per charge, per count, for counts 1, 2, and 3.
Would the court consider the scheduled amount of 1,000 each, Your Honor?
No, ma'am. Not in light of the fact that he got out of prison in August and was on bond for at least 2 other charges at the time this arose. In addition, Mr. Williams is being ordered not to return to the apartment complex at Northwest 45th Street in Deerfield where these incidents occurred. Do you understand, Mr. Williams?
Yeah.
Okay.
Thank you, Your Honor.
Thank you. All right, next up is the co-defendant, Gregory Roundtree.
Your Honor, he's a medical reset.
Okay. Next up is Ryan Davidson.
He's approaching, Your Honor.
Thank you. Good morning, Mr. Davidson.
Good morning.
Mr. Davidson, you're before the court on 1 count of grand theft auto.
I was never arrested for that, though.
Okay, sir, I don't want you to talk about the case. It looks as though it was this a not in custody KPS? Is that how this happened? Because this is an August 16th offense date. So, so the bond is already set, sir, in the amount of $1,000.
Your Honor, my client can't afford a bond at this time. He is asking if the court would allow him to do pretrial and check in telephonically.
What is Mr. Davidson's history, if any? Okay. I'm being told, just so you know, he had some sort of prior out of Tennessee, but they don't have the details of it.
You're on. All right. 1995 robbery adjudicated guilty. 2003 battery adjudication withheld. 2009 operating without a valid license was a traffic criminal adjudicated guilty. I'm trying to see something more recent if there's any. 2013 out of Broward petty theft adjudicated guilty. 2014 petty theft adjudication withheld. And traffic criminal again in 2018, suspended driver's license, first offense, adjudication withheld.
Your Honor, considering the most serious crime is from 1995 and all the other ones are misdemeanors, I'm asking if the court would again consider a pretrial and for him to check in telephonically.
Did Mr. Davidson go to prison for that 1995 offense?
He states no.
Okay. Okay. I will, let me just look at one thing. Okay, I'll allow Mr. Davidson to be on pretrial release. Standard. But he's ordered to have no contact with the victim, Leanne Hutchinson.
Thank you, Your Honor.
Do you understand, sir?
Yes, ma'am.
Okay, so you're gonna have to report within 24 hours of your release and then be calling in at least twice a week.
Thank you.
Okay, good luck to you, sir. All right, next up is Willie Houston. Good morning, Mr. Houston.
Good morning.
Okay, Mr. Houston, you are before the court on one count of robbery by sudden snatching. The court has reviewed the probable cause affidavit and does find probable cause. Does Mr. Houston have any priors?
2008 operating without a valid license, adjudication withheld. 2009 resisting without violence and prowling / loitering, both adjudicated guilty. 2009 prostitution lewd act assignation, adjudicated guilty. Prowling, loitering, adjudication withheld. 2010 trespass, adjudicated guilty. 2010 dealing in stolen property and false ownership info / pawn item, adjudication withheld. That was out of Broward. 2012 operating without a valid license, adjudicated guilty. More 2012 again, another case, a criminal mischief damage 1,000 plus, and battery, adjudicated guilty on both cases. And then 2008 procure for prostitution, adjudicated
So what's his most recent offense?
is 2018 procure for prostitution, and the 2012 felony would be the next one.
Okay. Can Mr. Houston afford a monetary bond?
No, Your Honor. I'm requesting if he can do pretrial release, Your Honor.
He can do level 2 pretrial release.
Thank you. See.
He'd rather stay in custody?
Yes, yeah.
You
Okay.
want a bond amount?
You want to bond him out?
Your Honor, if we could just set a bond amount.
Sure, bond will be set in the amount of $10,000.
Retrial.
He'll be set in the amount of $10,000. He'll also be ordered to have no contact with the victim, whose name is Juanita Hogabrook,
Thank
the
you,
listed victim. Thank you. All right.
Thank you.
Thank you, sir. Next up is Dwayne McManus.
He's approaching, Your Honor.
Okay. Good morning, Mr. McManus.
Good morning.
All right, sir, you are before the court on a violation of probation. You are being held no bond pursuant to the warrant issued by Judge Lynch. So you will be held no bond at this time. However, you do have a court date with Judge Lynch this Tuesday, November 5th at 8:30 in the morning. Okay, sir?
Yes, ma'am.
All right, thank you. Good luck to you, sir. Next up is Jean Blanco.
Your Honor, if on Mr. McManus, if we can request a phone order.
Sure.
For him to get contacts. Thank you.
All right, Jean Blanco.
Think he's a medical reset.
Medical reset, Your Honor.
Thank you. All right, next up is Vincent Antonelli.
Name, Your Honor.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Antonelli. You are before the court in count 1 on a grand theft charge, count 2 on a violation of probation. The court has reviewed the probable cause affidavit and does find probable cause for the charge of grand theft. Bond in that case will be set in the amount of $2,500.
What was 1,000 originally? What happened?
Your Honor, he's requesting for the bond to stay the scheduled amount of 1,000.
Okay.
He can't afford anything more.
And he's a habitual violent felony offender with a prior ag bat and a grand theft of a motor vehicle, for which he's on probation. He's also being held no bond in count 2. So bond will be set in the amount of $2,500, and in count 2, it's a no bond.
Ma'am, I had merchandise returned. Listen,
Sir, I would encourage you not to speak about the facts of the case. I can't hear him, just so you know.
okay, release it, please. I'm bipolar, schizoaffective. I'm denied medical help. I'm denied psychological help.
Okay.
I'm kicked out of Henderson.
Well,
okay, please.
Sir, just so you understand, you're going to have a court date on this Tuesday at 8:30 with your assigned judge. You're being held no bond as to count 2, regardless of what I set the bond at is count 1. Count 1, it is set at $2,500 at this time.
Your Honor, can we have order for him to be evaluated? For
Absolutely.
medicine?
Absolutely. He can have a medical and psychiatric evaluation.
Thank you, Your Honor.
Okay?
Brandon Jones?
Brandon Johns? Good morning, Mr. Johns.
Good morning.
You are before the court on 1 count of possession of alprazolam, which is also known as Xanax, and 1 count of possession of THC. The court has reviewed the probable cause affidavit and does find probable cause. Thank you. Can Mr. Johns afford the monetary bond?
Your Honor, he would be able to, but he needs an order to access his phone contacts.
Okay. So Mr. Johns will be given that order, and the bonds will be remain the standard bonds.
Thank you, Your Honor.
Thank you. It's 1,000 per count. Okay, sir? All right.
Thank you.
Next up is Felix Gonzalez. Less than 10 to go.
Your Honor, we have a corrected booking. He should have been charged with 2 counts of battery.
Okay. All right. Apparently, I'm being told that Mr. Felix's booking sheet is incorrect. And just to let everybody know, there should have been 2 counts of misdemeanor battery instead of 1.
Your Honor, so there's a count 1 robbery by sudden snatching, and there's an add-in.
So there's 1 count of the corrected booking sheet is count 1 is the robbery by sudden snatching, and then there are 2 counts of battery, of misdemeanor battery.
Thank you.
Okay, no problem. So, I have reviewed the probable cause affidavit. There are 2 listed victims in the case, so the court does find probable cause for all 3 of the counts. Is Mr. Felix able to afford a monetary bond?
My girl's working on it, Your Honor.
Your Honor, if it's a low bond amount or the scheduled bond amount, he would likely be able to.
Well, I don't know if your girl is either Lee De Los Santos or Marta Cuevas, but you're going to be ordered to have no contact with either of them, just so you understand, sir.
No, Your Honor, that's not, none of those 2 are my wife, Your Honor.
Okay. All right. All right, I'm just letting you know that you're not going to be, no matter what I set the bond at, you're not going to be allowed to have contact with either of them. Do you understand that?
I don't even know them, Your Honor.
Okay.
Very well.
All right. So bond will be set in the amount of $5,000 as to count 1, and then $1,000 for each of counts 2 and 3. Do you understand, sir?
Your Honor, would the court consider pretrial release?
It would be level 2.
What's level 2?
Means you have to wear a GPS monitor, sir, and you can only go to work, school, church, that's it.
Anyway, Your Honor.
Your Honor, if we could do that instead.
Okay.
Thank you, Your
So
Honor.
he will be placed on all 3 counts for level 2 pretrial.
Thank you, Your Honor.
Thank you.
The GPS, Your Honor?
With the GPS, yes. Level 2 means GPS. But I'll say it just for good measure. Do you need the corrected booking sheet back? No? Okay. You have a? Okay. All right. Next up is Enrique Irizarry.
He's approaching, Your Honor.
Okay. Good morning, sir. All right, Mr. Irizarry, you are before the court on one violation of probation. This is pursuant to the KPS issued by Judge Shearer. It is a no bond KPS, so you will be held no bond at this time. Do you understand, sir?
Yes.
All right, your next court date is going to be November 5th at 8:30. That's this Tuesday at 8:30 with Judge Shearer, okay?
Thank you, Your Honor.
Okay, thank you. Good luck to you, sir. Next up is Charles Newton. Charles Newton?
He's approaching, Your Honor.
Thank you. All right, Mr. Newton, you are before the court on a number of charges. Count 1 is a DUI fourth or subsequent offense. Count 2 is DUI with property damage. Count 3 is DUI with a blood alcohol level of 0.15 or higher or accompanied by a person under the age of 18. Count 4 is driving while license suspended, third or subsequent offense. Count 5 is careless driving, and count 6 is a violation of probation. As to count 6, there is a no bond hold, so you will be held no bond as to count 6. What is Mr. Newton looking for as far as counts 1 through 5?
Your Honor, if we can do the scheduled amount on each count.
Okay, well, on count 1, though, the bond is going to be in the amount of $2,500. It's a felony.
Well, Your Honor, considering that he can't be released on pretrial regardless because of his violation of probation, if we can just request the scheduled amount.
Okay, but count 1's going to be $2,500. There's no bond
Yes,
set
Your Honor.
currently, so I just want him to understand. So bond will be set in the amount of $2,500 as to count 1, $1,000 as to count 2, $1,000 as to count 3, $750 as to count 4. There's no applicable bond for 5, and he'll have a no bond hold as to count 6.
Thank you, Your Honor.
Thank you. Next up is Fritzen Alensi. Thank you.
He's approaching, Your Honor. And
Okay.
I believe that's the last person for me.
Okay. Good morning, Mr. Alensi.
He says good morning, Your Honor.
Good morning. So, sir, you are before the court on one count of grand theft auto and one count of contributing to the delinquency of a child.
Oh, excuse me, ma'am.
Okay, hold on. The court has reviewed the probable cause affidavit and does find probable cause. What is Mr. Alensi looking for as far as bond?
Sorry, Your Honor?
What is he looking for as far as bond?
Your Honor, my client's currently homeless. He cannot afford any monetary amount.
Does he have a place to live?
Yes, Your Honor, he's at a shelter.
Okay, will pretrial allow him to do it at a shelter? He's living at a shelter. Well, I'm asking, can he do standard? Okay, and his state, does he have priors?
Judge, I'm looking to see if he has right now an open case. May I have a moment?
Sure.
And Your Honor, it's the Covenant House. He's only
Oh.
19 years old.
Okay. Thank you for letting me know that.
No problem.
If they're juvenile priors, just let me know that they're juvenile. He has juvenile priors. Okay.
Honor, just to clarify with the court, my client has stated to me that he was at the Covenant House, and currently, if they have a bed available, he'd be able to go back, but that is all dependent on that. He's stating that he can afford a $500 bond if the court would allow for that. Otherwise, he'd have to go to Covenant House and wait for the process and.
Okay.
Your Honor, it seems that he does have an open case. It's not filed yet, but it happened where he went to magistrate on October 8th, 2019, tampering with or fabricate a third-degree felony and touch or strike, battery, and a petty theft. It's in front of Judge Al Spector under case number 19012222. 19012222 CF10A. The bond, he posted a bond on October 10, 2019. It looks for the amount of $1,000. Let me see. I don't see that. Yeah, I don't see the petty.
All right.
Based on that, Your Honor, on 191222 CF10A, I'm asking that the court revoke the defendant's bond based on the court finding probable cause.
Based on the fact that this case has just been sitting there, and he already posted the bond, we would be objecting to his bond being revoked at this time.
His bond will be revoked in case number 2019-1222 CF10A based on the court finding probable cause for the new charges. As far as this charge, I will set a monetary bond in the amount of $2,500 as to count 1, and I'll ROR him on count 2. So,
Thank you, Your Honor.
all right.
Yes, Your Honor, and I believe that's it for me.
Okay. Thank you so much
Thank
for
you,
your help
Honor.
today. Thank you.
No problem, thank you.
All right. Next up is Roderick Thomas. He was a medical reset yesterday. Does anyone know about Mr. Thomas? Anybody at Paul Ryan? Conti? Sir, what's your name?
He's next. This is Mr. Hall.
Okay. Does anyone know about Roderick Thomas?
Maybe check North Broward?
Hold on a second, Mr. Hall. He's still on medical loan? Okay, thank you.
You're welcome.
All right. So Mr. Thomas will be reset. He's on medical loan. Now we're up to you, Mr. Hall. Good morning, sir. How are you?
Good morning, fine, and yourself?
All right. Thank you for asking. Mr. Hall, you are before the court on a number of ad charges. Count 4 being a retail theft, coordinating with others. Count 5 being committing a theft with resistance to recovery of the property. Count 6 being a retail theft, coordinating with others. Count 7 being first-degree petty theft. Court has reviewed the affidavit and does find probable cause. What is Mr. Hall's total bond on counts 1 through 3? Do we know?
I'm looking for it.
Oh, okay. Okay. And that's a no bond on the out-of-state hold?
Correct.
Okay. So, I'm gonna leave the standard bonds for counts 4 through 7. So it'll be $1,000 on count 1, no charge on count 2, 1,000 on count, 1,000 on 4, nothing on 5, 1,000 on 6, 100 on 7. But sir, you're being held no bond on counts 2 and 3. Do you understand that?
Yes, I understand that. Can for the petty theft we resolve at the D?
No, you cannot resolve these today. I'm sorry, sir. The only other thing I'm going to tell you is you are not to return to the Lowe's on University Drive in Pembroke Pines. Do you understand, sir?
Yes, ma'am.
Okay. Good luck to you, sir. All right. Next up is Ronald Jeanette.
He's in North Broward.
It's going to be a medical reset, Your Honor.
Okay. Thank you. All right. And last but certainly not least is Alexander Arengo, which was a medical reset yesterday. Is he here today?
No, Your Honor, he's still on medical.
Okay. Medical reset. And does that conclude the court's docket, according to everybody?
Yes.
Yes? Going once, going twice?
That's what I see.
All right. Thank you very much, everyone who can hear me, for your help this morning. Take care. Have a great day.